Hi everyone. In this video, I'm going to explain to you about the system of court in Malaysia, where we are going to discuss about the administration of justice in terms of the functions and the jurisdictions of each court in Malaysia. The courts in Malaysia are divided into two divisions. One is superior courts, Mahkamah Atasan, and the other one is subordinate courts, Mahkamah Bawahan atau Mahkamah Rendah. As for the superior courts, we have Federal Court, Court of Appeal, and High Courts. With regard to the subordinate courts, we have two kinds of courts. They are Sessions Court and Magistrates Courts, which this Magistrates Court is divided further into two. One is First Class Magistrate Court and Second Class Magistrate Court. As for Sabah and Sarawak, we have another branch of court that is Native Court. Under this topic, you are going to learn about the functions and the jurisdictions for each court in the hierarchy of courts mentioned just now. The most highest court in Malaysia is the Federal Court. This is the final appellate court, Mahkamah Rayuan yang terakhir in Malaysia. The decision of this Federal Court is binding upon all the courts below. Previously, after the independence and prior to 1985, the final Court of Appeal for Malaysia was the Privy Council. It was then abolished and replaced by the Supreme Court in 1985. And finally, in 1994, the Supreme Court was renamed as the Federal Court. The Federal Court has three types of jurisdiction. One is appellate jurisdiction, original jurisdiction, and advisory jurisdiction. For the appellate jurisdiction, it is provided under Article 121, Clause 2 of the Federal Constitution, which confers the power to the Federal Court to determine any civil and criminal appeals from the decisions of the Court of Appeal. Maknanya, fungsi bidang kuasa rayuan Federal Court adalah untuk menentukan sebarang rayuan sivil dan jenayah from the decisions of the Court of Appeal relating to matters which was decided earlier by the High Court in the exercise of its original jurisdiction. Maknanya, bidang kuasa rayuan Mahkamah Federal adalah menentukan kes-kes rayuan daripada Mahkamah Rayuan atau Court of Appeal which the cases was decided earlier yang telah diputuskan pada awalnya oleh Mahkamah Tinggi dalam bidang kuasa asal High Court tersebut. This is the illustration. Let's say there is a case which was originate from the High Court. Case tu asalnya daripada High Court and the High Court has made the decision for the case. However, the parties in the case not satisfied with the judgment, so they can appeal buat rayuan to the Court of Appeal, Mahkamah Rayuan. And this Court of Appeal will make the decision either against or approving the decision of the High Court. So if the parties not satisfied with the judgment, they can further appeal to the Federal Court. So Federal Court will make the final decisions about the case. So this is the example of the appellate jurisdiction. Fungsi bidang kuasa rayuan Mahkamah Persekutuan atau Federal Court, yang mana Federal Court is the court which give the final decision for the case. This is the highest court which make the final decision for any appeals from the lower court. The second jurisdiction for the Federal Court is original jurisdiction ataupun bidang kuasa asal. Under the Article 128 of the Federal Constitution, there are three kinds of original jurisdiction. Maknanya, the following cases will start ataupun will originate from this court. Kes-kes sebegini tidak akan dibawa ke mahkamah lain. Only the Federal Court has the jurisdiction to solve or to try the cases involved. So what are the cases? The first one is that any question as to whether a law which was made by the parliament or by the legislature of a state is invalid. It is the jurisdiction of the Federal Court to decide in terms of the validity of the law which was made by the parliament or made by the state legislative assemblies, on the ground that maybe the parliament or the state legislative assemblies has made provisions, membuat undang-undang ataupun peruntukan with respect to a matter where they has no power to make such laws. Maknanya, katakanlah jurisdiction parlimen hanya boleh buat law yang berkaitan bawah federal list. However, the parliament make the law which is relating to the state list. So this one, in terms of the federalist and statelist, you can refer back to the topic of legislative process. Or maybe the state legislative assemblies make laws relating to the matters which is under the federalist. The state legislative assemblies has no power to make such laws, and therefore the law was invalid. So this is the jurisdiction of the federal court to make the decision in terms of the validity of the laws. The second matters which is under the original jurisdiction of the federal court is the disputes, pertelingkahan ataupun ketidaksefahaman between the states or between the federation and any state. Maknanya antara negeri dengan negeri atau antara kerajaan persekutuan dengan kerajaan negeri. So if there is any dispute on certain matters, maybe in terms of the administration, so in this situation, the dispute would be brought to the federal court. No other court can solve or can try this kind of cases because this is the original jurisdiction of the federal court as is provided by the Article 1 to 8 of the Federal Constitution. And the last one, the original jurisdiction is to determine any question arises in other courts as to the effect of any provision of the Constitution. If there are any issues relating to the Constitution which was brought up in other lower courts, so this matter would be brought to the federal court as to the determination of the effect of any provision, apa-apa maksud atau kesan ataupun kepentingan pada peruntukan-peruntukan di dalam perlembagaan mestilah diputuskan oleh Mahkamah Persekutuan or Federal Court. No other court can decide on these matters. So these are the three matters which must originate in the federal court. The federal court to decide on these three matters. And the third category of jurisdiction of the federal court is advisory jurisdiction sebagai badan penasihat to the Yang di-Pertuan Agong. So if there is any constitutional questions, sebarang masalah-masalah yang berkaitan dengan perlembagaan, so the matters are to be decided by the federal court, where federal court akan give the advice to the Yang di-Pertuan Agong. By virtue of this Article 130, the Yang di-Pertuan Agong may refer to the federal court for its opinion, for any issue, any question as to the effect of any provision berkaitan dengan penguatkuasaan sebarang peruntukan of the Constitution which has arisen or appears to the Yang di-Pertuan Agong. This jurisdiction is only for the federal court by virtue of Article 130 of the Federal Constitution. To sum up, there are three types of jurisdiction of the federal court. One is appellate jurisdiction, bidang kuasa rayuan, where the federal court will make the final decision for the appeals made from the lower courts. That is, the cases which has been brought up to the court of appeal, but the parties were not satisfied with the judgment or maybe on certain matters. Therefore, the federal court will make the final decision for the case. The second jurisdiction is the original jurisdiction. There are three situations where the cases must be handled by the federal court only. Only the federal court has the jurisdiction to try or to decide on the matters as provided under the Constitution. And the third jurisdiction is advisory jurisdiction, where the purpose of the federal court is to advise the Yang di-Pertuan Agong in terms of the constitutional matters which appears or arise brought up by the Yang di-Pertuan Agong.